Well, hello. I'm Peter Lamont. For those of you who follow the channel and you participate with us either through our social media or through our radio station, you'll know who I am and what we do. I'd like to welcome you today to something that we're going to try brand new, and it's going to be a live Q&A. We're going to do legal Q&A. I'd like to see how you guys like this, whether or not you think this is something that you'd be interested in having on a weekly basis, because if so, I think we'll try to plan it for once a week. Wednesdays probably at 2 o'clock, and hopefully it will be helpful to you, because the goal of this is to go through some of the legal questions that we've received from people during the week, and obviously hopefully you guys will join the chat and ask your questions here too. So what I want to do is I want to right now take a quick look at some of the questions that have come in, and we're going to go through them one at a time. And I want to give you some obvious information about what you can do in certain situations. If you have legal questions, if you've got questions that you've been hesitant to ask a lawyer because you don't want to have to spend money to get an answer to your question or to figure out if you have a potential claim, this is your opportunity to do it. Obviously, this is free, streaming live on YouTube. We don't get anything from this. This is part of our social outreach. I think it's really, really important that people understand the law and understand their rights and obligations under it. And that's why we do this. I like to help educate people about the law and their legal rights. They ultimately become better clients down the road, and they're better able to protect themselves from either making mistakes or when things go wrong. So let's jump right into this and ask the first question. So we received a question, and this one is, how do I adjourn a motion? So how do you adjourn a motion? This person is pro se. Apparently what's going on here is she is a plaintiff in a lawsuit, and she's filed it pro se, meaning by herself without the help of an attorney. And the defendant has submitted a motion for summary judgment. And a motion for summary judgment is a motion that is essentially a trial on paper. If you lose a summary judgment motion as a plaintiff, right, the defendant files a motion for summary judgment and you lose, your case is over. Now, you might have a right to appeal and other things that are unique circumstances, but a motion for summary judgment is called a dispositive motion because it disposes of a particular complaint or claim or cause of action. And so this individual's question is, how do I adjourn this motion? So she's the plaintiff, the defendant filed a motion for summary judgment, and she wants to adjourn it. It looks here like she wants to retain an attorney, so she wants time to go do that. All right, so let's go through number one, how do you adjourn a motion? And then what could this person do that would be beneficial for her? So adjourning a motion, depending upon the state you're in, is a relatively simple process. Most states require that you ask permission from the other side to adjourn the motion and get the other side's consent. If you get the consent of the other party, you simply, in most states, write a letter to the court and you say, there's a motion returnable before Judge so-and-so on such and such date, and I'm requesting that this motion be adjourned. Sometimes you want to put the reason in why you want it adjourned. And then you'd include a line that says, I've spoken to my adversary and I have his or her consent. And you submit it to the judge, and the judge decides whether or not you're going to get that adjournment. Now, adjournments are at the discretion of the court unless there's a statute or court rule that gives you an automatic extension. So in New Jersey, there's a rule concerning discovery demands and discovery end dates and things like that, which we can talk about, at another time. And it gives you an automatic right to a 60-day extension if you file a letter, serve a letter on the court, and notify the other side. So that's the easy way to do it. But again, it's at the discretion of the court unless there's a statute. So the judge could look at this and say, there's not a good enough reason for me to adjourn the motion. I'm not going to do it. Maybe they think that it's a delay tactic, that you're only requesting the adjournment because you don't want to move forward with the case at this time. You're trying to stall. So if the judge says no, then that's the answer to the question. No. If the judge says yes, then you get it adjourned. Now, in this person's scenario, she's looking to retain an attorney to represent her to defend this summary judgment motion. So she's got, according to her comment here, her question, she's got 10 days to file opposition to the motion. So she's got two options. She can write to the court herself, pro se, and indicate that she is looking for an attorney and that she'd like an extension of time to respond to the motion and otherwise adjourn the motion to a later date. Or she could go out within these 10 days, get an attorney, and have the attorney send the request. In a case like this, where an individual is looking to get counsel to represent him or her, courts are relatively lenient, and they will allow the time necessary to get representation. They do that, quite honestly, because courts favor litigating cases on the merits and with fairness. So while I've often said to people who have called the law is not fair, it's not fair. I mean, the law is the law, and interpretation of it, representation or misrepresentation of factual issues, all go into someone's decision on a case, like a judge or a jury. So it's not fair, but it's the best system that we have, and it works. So, obviously you're going to say, oh, well, there are some people that go to jail and they didn't commit a crime. Yes, there are flaws, but for the most part, the legal system works. So getting back to the question, so if I were her, I would feel more comfortable probably if I was pro se, sending the letter in, letting the judge know right away that I need an extension of time or an adjournment, and that I need it because I'm trying to get legal representation. So if I were her, that's what I would do. And I was pro se. I'd send the letter in now. Okay. Now, before I continue, I just want to let everybody know that if you have questions, if you want to leave comments, which are greatly appreciated, please do so under the video here in the comments section. You can join the chat and you can ask your questions live. I'll be happy to answer them. I also want to remind everybody about our free app, which is available on the iTunes store for iPad and the iPhone. And it has a unique feature different than any other lawyer's app, and it allows you to ask questions directly from your iPhone or iPad, and those questions get sent to an attorney in my office or myself, and one of the attorneys here will answer your question. So you don't have to hunt around on the internet and try to find answers to your legal questions and hope that you're getting the advice of an attorney. Use the app, ask a question, and it's free. And again, it's part of our outreach, our desire to help educate people on the law. All right, so getting back to the questions. The next question is, can my boss demote me without any proof of wrongdoing? So let's talk about that for a second. Well, you've got to figure out first, what kind of employee are you? And there's generally two types of employees. There are contract employees, people that have a signed contract that say you're going to be hired for 5 years and this is the salary you're going to make and this is the increase that you're entitled to. And then there are at-will employees, which is what 95% of America is made up of, at-will employees. It means that you accept conditions of employment and that you can leave whenever you want if you don't like it, and you can be fired for any non-discriminatory reason. So obviously somebody can't fire you because they don't like the color of your hair, or, well, that's not a good example. Let me take that back. If they don't like the color of your hair, that's not necessarily discriminatory. If for some reason they didn't like you because of your skin color or your race or your creed or any of those things. I got carried away with the hair comment. Maybe I wish I had hair, and that's why I said it. But anyway, it has to be a non-discriminatory reason, and as an at-will employee, you can be fired. So it's quite simple. So we have to determine, what are you? Are you a contract employee or are you an at-will employee? And let's assume for today's purpose that you're an at-will employee, because just about everybody is. Can you be demoted if your boss believes you did something wrong, but there's no proof of it? And the short answer here is yes. Just because you've got rights as an employee to protect yourself from discrimination or a hostile work environment doesn't mean that you have the freedom to do things that are inappropriate or improper in the workplace and not expect some sort of repercussion. In fact, let me talk to you about this for a second. Did you know that 99% of the workplaces in the United States, with the exception of very, very rare companies, you as an employee, you have no expectation of privacy in your office stuff, your computer, your desk drawer, anything. And so what does that mean? Well, that means that an employer can look through your computer, look through your desk. They can check your email. As a matter of fact, when you work for a company that has a server where email is going through a server, and that's just about everybody, you have, as the company, you have all those emails stored on a server. So you're entitled to go and look at them anytime. So there's no expectation of privacy as an employee, and I don't think enough people are aware of that, because they become indignant. Oh, why did my boss go through my desk? That's not fair. That's not right. Well, it is fair and it is right, because an employer can do that sort of thing. They can investigate for no good reason, right? They can just every day go through and do a drawer check, make sure that there's nothing in the drawer that's inappropriate. They can check your computer every day. You have no expectation of privacy. So what's the lesson here? Don't do things at work that are inappropriate, because you will get caught. Don't do things at work that are of a personal nature, because if your employer frowns upon that, they will find out. But to answer the question, again, can you be demoted without proof of wrongdoing? Yeah, if you're an at-will employee and your employer says, Sally, you are the the bookkeeper, you're the head bookkeeper in this company, and for whatever reason, be it money, maybe he doesn't think you're doing a good job. Obviously, this question deals with wrongdoing. Can he demote you? Absolutely. There's no discrimination there. If you did something wrong, you can be demoted. You can be fired. Oftentimes, and I don't really understand it, it's quite bizarre. Oftentimes, people who are employees, they don't have the best interests of the company at heart. And unfortunately, they do things that are quite stupid. For example, they'll sit in your office during the workday and work on personal things. Clearly no employer, unless there's some unique circumstance. My sister works for a university, and she's in the administrative offices, and there's a lot of downtime, and they know it, and she's starting a cookie business on the side. So her boss said to her, listen, there's so much downtime in the summer, there's really nothing to do. I don't have a problem with you if you were to work on your website during the summer slow time. So that's okay, because she got permission for it. But if you don't have permission for it, don't do personal stuff at work. Obviously, A, it's not fair to the employer, and B, it's going to get you in trouble. So I don't understand people that do that, but believe it or not, they do it, and it happens quite often. And I'm not talking about the occasional, let me send a quick email to my daughter to make sure she's okay. I'm talking about somebody that's playing a game, going on Facebook all the time, writing letters for family members, things that you should not be doing at work. So if an employer were to find out that that's what you're doing, yeah, absolutely. They can say, hey, listen, you're demoted, you're fired, whatever the case may be. So as long as you're not being demoted due to a discriminatory reason. So if you're 62 or 63 and you're doing a great job and everybody's happy with you, and the next thing you know, you're demoted and there's a 22-year-old in place of you, Well, that's something that maybe you need to investigate, because is there discrimination there? Is there age discrimination? And was the employer trying to bring in someone who has a lower salary perhaps and replace you with that person? That's a separate issue. Just general wrongdoing, you can be demoted. And in fact, if the employer just doesn't like your attitude, you can be demoted, you can be fired. No restriction to that. So we just dealt recently with a company who had an employee that was there for a relatively short term, and unfortunately thought that it was okay to do personal stuff at work and involve the company, so using the company letterhead and that sort of thing. And that's clearly not something that is permissible, and something you should not engage in, because there's more than just the possibility of being demoted out there if you engage in conduct like that. So just be aware of that. All right, moving along. Now we've got a question about a roommate. How can I get a roommate who doesn't pay their share of the rent out of my apartment? All right, so there's no easy answer to these things, by the way. Like, don't you just wish that I could say yes, no, yes, no, yes, no? But instead, there's all sorts of qualifiers that we need to figure out first. So you've got a roommate that doesn't pay their share of the rent for the apartment. First question, do you have some written agreement with your co-tenant? Do you have some sort of sublease agreement? Do you have a joint lease? Do you have a separate standalone contract? Do you have anything in writing that says that that person was obligated or had agreed to pay you a portion of the rent? If you do, great. If you do, obviously your case is a lot easier. All you would essentially need to prove is, here's my contract, so-and-so, my roommate agreed to it, and they haven't paid me. It's pretty straightforward. In the event that you don't have something in writing, which unfortunately so many people don't, you go to the grocery store and you see those little things up on the pegboards, and they've got the, pull off a number, do you need a roommate? You see that a lot, and people are just trustworthy, especially younger people. Maybe it's somebody who's in college and they're renting an apartment and they need a roommate. There's not a lot of thought that goes into, well, do I need an agreement? What could happen? What could go wrong? And really, it's something that you need to be aware of. And if you're a parent and you've got a child who's in college going to rent an apartment, you need to protect yourself, because there's liability aside from obviously non-payment of rent, but there's other liabilities that you have to be aware of. We can talk about that. In fact, we are going to be talking about that in one of our upcoming Understanding the Law radio broadcasts. By the way, that show airs on Thursdays at 10 o'clock Eastern Time, and it's live, so you can call into that as well. But in September, we're going to be doing a segment on back to school, and that's one of the things that we're going to touch on, which is liability associated with college and high school and rentals and roommates and that sort of thing. So if you've got questions, send them in for that, and we'll be able to discuss them in September during our back to school segment on Understanding the Law Radio. If you want to learn more about Understanding the Law Radio, just go on over to utlradio.com, understandingthelawradio.com, utlradio.com. There's a program schedule. There's an opportunity for you to leave comments and suggestions and that sort of thing. But in the case of this woman, or man, if there's no written agreement between you and your roommate, then you're going to have to resort to other proofs, and they're more speculative in nature, and it becomes a more difficult case to prove. So let's assume for a second, your name's Sally and your roommate's Terry, and there's nothing in writing between the two of you, but Terry was giving you cash every month, and 3 months later decides not to pay you anymore. You have a really tough case here, because you've got to be able to prove that you weren't just allowing Terry to live with you, that Terry was actually obligated to pay rent, that Terry didn't do so under or out of just simple thoughtfulness to you. And if Terry's a bad person, Terry's going to say, no, I never agreed to do anything. I never agreed to pay anything. I was told by Sally that I can just live here, right? I mean, that stuff happens all the time. And that's where I tell you that, is the law fair? No, because people lie, and that's a fact of life. So, those of you who used to watch that show House, I think it was on Fox, the one with Hugh Laurie, he was the doctor. It's kind of like a Sherlock Holmes-based show. One of the things that he always said was, everybody lies. And unfortunately, it's true. While you've got to have trust in people, people lie. So you're going to be in a situation like this with your apartment, and if that person lies and says, no, it's not true, now it's, your word against his or her word, and ultimately that sort of question of fact is something that would be decided by a jury. So what can you do to answer that question? You can send a letter, which you should do, and the letter should be sort of like a self-serving letter, and it should indicate, dear so-and-so, we agreed on September 1st that you were going to be a roommate with me in the apartment, located at, and give the address. You agreed to pay X amount of dollars per month. You did so up until 2 months ago. Now you haven't paid the rent. And if you don't pay the rent, I'm going to kick you out. I'm going to seek legal action or pursue legal action against you, any of those things. So if they don't pay the rent and you don't have a signed agreement, you can kick them out, but you've got to do so in a way that doesn't create liability for you. And if you have a signed agreement and they've breached that, then that's really simple. Here's the agreement. You didn't pay me as promised. See you later. So short answer, kick them out. Make sure you've got documentation and proof. Send a letter. Let them know. Don't just lock the door and they come home and they can't get their stuff. That's another thing. Give them their stuff. Let them take their stuff. Let them go. In the event that you decide to sue them later, you still have your rights. But if you hold their stuff, you're opening yourself up to a claim, and it's not worth it. So, all right. Next, we've got, do non-disclosure agreements cover information that is public but not well known? Okay, now this is an interesting question, and I don't know the context necessarily for this question. Let me just see how we're doing in the chat room. See how many comments we have. Okay. All right. So getting back to this question, the non-disclosure agreements, what do they cover? Well, let's go one step at a time. What's a non-disclosure agreement? It's an agreement that you sign, typically with an employer, that says you're not permitted to disclose or talk about certain information. It could be anything from salary, it could be trade secrets, it could be the way that they operate their business. Whatever it is they're trying to protect, they ask you to sign a non-disclosure agreement, and it says that you're not going to disclose the information to anybody. Sometimes there's a time limit in those non-disclosures. They shorten them to say NDAs. Maybe it's, you sign an NDA and it lasts for 2 years after you leave the employ of that company, or it can be perpetual. It could just be forever. You're never allowed to sign it. And it's not just the CIA or the government that would make you sign an NDA. Every company who's on top of protecting themselves should be requiring employees and even contract workers to sign an NDA. You want to protect what you've worked so hard to build. So a non-disclosure agreement protects or prevents an employee or a contract worker from disclosing whatever information you seek to keep private. Now, obviously, it's not like putting duct tape over their mouth, right? They can still go out and do it, but it gives you a legal remedy that you can sue them, and you can sue them for damages. This question asks about non-disclosure covering public information, but that's not well known. Well, if it's public information, then you can't submit or request someone to sign a non-disclosure agreement if it's public, even if it's not well known. If it's public knowledge or public record or or something that can be looked up on the internet. Maybe you've got to delve into it a bit. You can't really protect against that. So that would be, for example, somebody puts together an annual statement for a corporation, and they post their annual statement on their website. But it's in like this drop-down list where, to get to it, you've got to click 32 screens, and ultimately you stumble upon it. So it's not out there on the main page, hey, look at our annual statement, but it's there public. Could that company say to an employee, you're not allowed to discuss anything that's in the annual report? That depends on how they word the non-disclosure agreement. So if they say you can't talk about the methodology or how we compiled the information for the annual report, that's something you could protect against. If it's simply the results, here's the annual report and it's online, it just takes a lot of effort to go find it, you can't have somebody sign a non-disclosure agreement for that because it's public. So general rule of thumb is public knowledge, public information, not subject to an NDA. And quite frankly, the company would have no interest in doing that anyway. If it's public knowledge, there'd just be no interest in trying to protect against some sort of disclosure of that information. Okay, next, is the oath given at a deposition binding? So everybody know what a deposition is? If not, I'll give you the quick rundown. Deposition is part of the discovery process of a lawsuit. It is essentially a question and answer session where you sit down, generally at an attorney's office, and there's your attorney, another attorney. Sometimes you've got multiple parties in a lawsuit, so maybe there's more than two attorneys, and a court reporter or a stenographer. And, you think of a court reporter or a stenographer typing in the little tiny steno or stenography machines. It's kind of evolved a bit now. Most of them use the same type of machine, but it's connected to a laptop. And so same idea, though. And it's a question and answer session. So you sit down and assume you're the witness. You've been subpoenaed or noticed for the deposition, and the other attorney is going to start questioning you. Before you start the questioning, the stenographer or court reporter says to you, raise your right hand, I'm going to swear you in. You raise your right hand, and she gives you the same oath that you would receive at trial. Do you swear to tell the truth, or that everything that you say today will be truthful? It doesn't necessarily need to be the old, do you swear to tell the truth, the whole truth, and nothing but the truth? You can administer an oath that's a little more modern, like, do you understand that you're under oath, and do you swear that all your testimony here today is true and accurate? Done. So you're sworn in. So is it binding is the question. Well, absolutely. If you are sworn under oath, because a court reporter is qualified to swear you in, if you're under oath at any time, whatever you say can be used. It's considered binding. Depositions, in particular, your testimony that you give at a deposition has the same force and effect as if you were testifying in front of a judge and a jury at trial. And as a matter of fact, attorneys give out instructions at the beginning of a deposition. Let me walk you through some of my instructions that I typically give out at a deposition. And I'll kind of walk you through the process. So you raise your hand, the court reporter swears you in, and then she'll say, all right, Mr. Lamont, you may proceed. And so I'll introduce myself. Hi, my name is Peter Lamont. I represent so-and-so. Let's do a scenario where I represent a company. So, hi, my name is Peter Lamont. I represent Company A in a lawsuit filed by you. How are you? And then they'll say, I'm fine. And I'll say, we're here today to conduct a deposition. A deposition is essentially a question and answer session where I am trying to figure out certain facts that will help us move the case forward. And then I start giving them specific instructions. Your sole obligation here today is to tell the truth. Okay? You have an obligation to tell the truth. Obviously, you realize that you're just sworn in, and whatever you say today can be used against you. It has the same weight or force and effect as if you were testifying before a judge and a jury. The fact that we're here in an informal setting, be it your attorney's office or my office, wherever we are, is of no importance. Your testimony still counts. And then we go on to other instructions, like, for example, if you don't understand a question that I'm asking, don't just give an answer. If you don't understand the question, tell me. I'll rephrase the question. Don't guess. If I ask you for an estimate, well, then that's appropriate to give an estimate in response. But if you don't know the answer to a question, don't make something up. Just tell me I don't know. There's instructions about talking slowly and letting the attorney finish the question before you answer, even if you might know what it is. I give the instruction about, unlike normal course of conversation where you might know what I'm going to say or going to ask, and then you give the answer before I finish, we're here at a deposition, and the court reporter is tasked with writing down verbatim everything that we say, and it will be put into a book at the conclusion of this deposition called a transcript, which the attorneys can use at trial. So all those instructions are given, and obviously the answer to this question is yes. If you are sworn in under oath at a deposition, it is binding. The same binding effect as if you were testifying in front of a judge and a jury. All right. Here's an interesting one. How much is a contingency fee? Well, let's talk for a second about the way that attorneys bill. So nowadays you're finding a variety of billing called alternate billing methods, and I'll get into that in a second, but traditional attorney billing is either hourly, or if it's a particular type of case, generally plaintiff's personal injury case, an attorney will take a case on a contingency basis. So clearly hourly is straightforward, right? You get charged a set amount of money per hour, and the attorney keeps track of his or her time, sends you a bill, you pay the bill. That's hourly billing. Contingency is essentially the following. I'll take your case, and I don't take any attorney's fees unless I recover for you. Right? You've seen these things all over TV, no attorney's fees, you don't pay anything unless we recover, all that sort of stuff. But the typical percentage, at least in New Jersey and mostly across the country, is 33 1/3%. Sometimes you'll see an attorney take less. They can take whatever they want as long as they don't take more than they're permitted to take by law. But while most attorneys take 33 1/3 in New Jersey, if you have an attorney that says I'm going to take 20%, that's permissible. But 33 1/3 is the standard. One thing I want to talk to you about with respect to contingency fees. All those great commercials like the used car salesman lawyers saying, you don't pay anything unless we recover. Well, what they don't tell you is that you are responsible for the costs. Listen to those ads next time you see them. Listen to what they say. Go look on somebody's website that says, you don't pay attorney's fees. Look at what it's saying. You don't pay attorney's fees. It doesn't say anything about you don't pay costs. It says, if we don't recover, you don't pay 1 penny in attorney's fees. That's true. But there are costs associated with filing a lawsuit. There is the cost of, perhaps a private investigator if it's a personal injury case. The cost of filing the complaint. The cost of filing motions, the cost of an expert witness, the cost of depositions, the cost of witnesses to testify at trial, subpoena costs, all these costs. And at the end of the day, some firms will agree not to charge the costs if they don't recover, but the majority of firms that say no fee unless we recover, because this is a contingency case, will require you to still pay the costs associated with the case. A few years back, I was helping this older gentleman, and he had a lawsuit with a relatively large firm in New Jersey. He lost. He was the plaintiff. He lost. He was under the belief that it was a contingency basis, which it was, and then he got a bill for $22,000 from this law firm. They said, you owe for this and that and this and that, deposition fees, all those things that I just listed. And he didn't have the money to pay that. That's the reason that he went to a lawyer that would accept it on a contingency basis. And ultimately, we were able to settle it and resolve it, but he still had to pay some money. But there's like that fine print. If you look at the retainer agreement that a contingency lawyer sends you, it says right there, or should say right there, that you're responsible for the costs. So contingency fee could be anything so long as it doesn't exceed what's allowable under state law. Generally speaking, it is 33 1/3 of the recovery. Oh, and it's after expenses are taken. So in an example for a personal injury case, so you have a personal injury case, you sue somebody, right, and you receive, let's just for easy figuring say $10,000. Your attorney has laid out for you $2,000 in expenses, filing the complaint, some other stuff. So now you get your award of $10,000, and the attorney is entitled to 33 1/3. But what happens is they take the $2,000 in expenses off the top because that's not part of the percentage. So now you're left after expenses with $8,000, and then the attorney takes his percentage. You have to look at that because there are firms that will do things like they'll take their percentage off of the full amount. They don't tell you what the expenses are, all sorts of things you have to be at least aware of. But that's the answer to that question about contingency fee. All right, here's another good one. Can an implied or oral employment contract take precedent over a written contract? Well, this is another hard one because generally speaking, when you sign a written agreement, it's going to say this agreement supersedes all other agreements. So whatever oral or prior written agreement you have, your new written agreement will say that what's in here trumps or supersedes all of the other agreements. Are there times when an oral agreement can take precedence over a written agreement? Yes, there are. Assume for a minute that you have an employment contract with a particular company, and it says that your job will be a level 1 employee, and then you have an interview, not an interview, but a job review with your supervisor or boss, and your job or supervisor says to you, "You have done such an outstanding job. I've spoken to management, and we're going to promote you to level 2. Congratulations, way to go. It comes with an increase in salary. You get a few extra days off, so you deserve it." And you're all excited, right? And you walk out, and next week comes, and you think you're going to get a level 2 pay, and your pay rate doesn't change, and you go in and you say to the person, "I thought you told me I was going to be level 2. And they say, "Well, no, we've changed our mind." Could that be enforceable? It could be. It could be. It's not an easy case. An employer can change their minds, but just keeping it simple and to just try to give you a basic example, yeah, I mean, there are times when an oral agreement or oral contract can trump something that's in writing. It essentially depends on the timing of the agreement. So if the written one is first and then there is some sort of subsequent oral or verbal agreement, yeah, it can trump it. So, but again, not an easy case. Let's just check over here in the chat room. Okay. Let's see how much time do we have. We've got about 20 minutes left. I don't know if we're going to go the full 20 minutes today. I'd really like to see what people think about this question and answer forum, because if it's something that you guys aren't into, obviously we won't continue it, but I do think it has some benefit to it, and I'd like to hear your feedback on that. So, all right, let's look at this last one. We'll get through this one, and then we'll wrap up for today. I signed a non-solicitation of employees agreement with my former employer. One of my former coworkers quit their job with that employer and now has asked me for a job. Can I hire them without violating the agreement? Can I be sued? So a lot has to be fleshed out here before I could give a proper answer. We'd have to know what the terms of the non-solicitation agreement were. How long are the non-solicitation terms in effect for? Does it say that you can't solicit workers, or employees? See, this gets complicated because it's a lot of the wording in the agreement. So let's say, for example, there's a non-solicitation agreement that you sign that says that you will not, if you were to leave, you will not poach employees from company A. If the language reads something to the effect of, you are not permitted to approach employees and ask them if they want to come with you or offer job opportunities, what's the key word in that sentence? And it is employees. This question says if they've quit their job, so now they're no longer an employee, could you solicit that person? Absolutely, if that's what the non-solicitation agreement says. Sometimes you'll have a non-solicitation agreement where the employer will try to prevent you from ever in your life, going after a former employee and ask them to work with you. And a lot of times those are found to be unenforceable. So it's interesting. And then obviously the can I be sued? Well, here's another tricky answer. Can you be sued? Yes. Why? Because our legal system is set up so that as long as you, on the plaintiff's end, believe that you have a good reason to file a case, a good faith basis, you can file a complaint. Are you going to be successful? Well, in the scenario I gave before, where it is an employee who quit their job and is now no longer an employee, and the non-solicitation agreement says that you can't poach employees, then can you be sued? Yes. Will you lose, or will the other side win? No. You can defend that claim because of the language and the way that the wording is in the non-disclosure or non-solicitation. Keep getting those mixed up. So that's the answer to that question. I think we're going to shut down for today. I open this up for you guys to leave comments and questions. Let me know what you think about this. Let me know if this is something that you find useful, and if you would be interested in this time slot. Wednesday at 2 o'clock Eastern time. Is everybody at work? Is there nobody out there looking for answers to the questions at this time? Let me know. Give me your feedback so we can adjust the schedule and make it something that would be beneficial to you guys, because that's what we're doing it for. Also, just want to remind everybody that tomorrow, Thursday, tomorrow's the 7th, 10 o'clock Eastern time, we have Understanding the Law radio program, and tomorrow's guest is Alan and Carolyn Fisher. Alan Fisher is a world champion arm wrestler, I believe he's 26-time world champion arm wrestler. He was featured on the AMC show last year or early this year, maybe it was January, A Game of Arms. So he's going to be on with Carolyn, his wife, to talk about overcoming adversity and belief in yourself and the importance of dealing with struggle and moving forward, and how to be a champion in life and in business. So it's going to be a really great show tomorrow. That is 10 o'clock Eastern time. Now let me just get you real quick the call-in number for the radio show. I'll put it in the notes underneath the video, but just so you have it. It's a live show, and you'll be able to call in. It's 347-855-8831. You'll be able to call in and ask your questions live on the air. You can talk to Alan, talk to Carolyn. For those of you who've watched the show Game of Arms, Alan's a fascinating guy, and I think he's got a lot to teach us as individuals and as companies. He's got a lot of good advice. He's also doing some motivational and public speaking now, and he and his wife Carolyn have a company that we're going to talk about, all about motivation, self-motivation, and teaching people how to really be a champion. So we look forward to that. You can find more information about that over at Understanding the Law Radio, utlradio.com, and you can read more about Alan. His bio is on the site. So that's tomorrow, 10 o'clock Eastern time. Tune into that. You can go right to our website and click on the radio player, and it'll take you to our page on Blog Talk Radio, where you can then look for the live episode. Just scroll down a bit and it'll show you which episode is live. And call in, listen to the show. Love your comments. Appreciate it. And one last time, I want to remind you to make sure that you comment on this video. Let me know if this is something that you want to see more of, and we'll continue to take in questions and hopefully engage you guys live and answer your questions live on air. So thanks for watching this video if you download it or view it later. For those of you who are live with me today, thanks for watching. Have any questions or any comments, leave them below in the comments section. Don't forget to subscribe to our channel. We've got live broadcasts and a lot of instructional videos that we put up for free, as well as videos from the Understanding the Law show, which is a Monday and Thursday radio show. So I'm going to sign off for today. I want to remind everybody that there's power in understanding the law, and it's really important for you to know what your rights are and your obligations. That's why we're doing this. So join this discussion with us. I will be live tomorrow on Understanding the Law Radio. Tune in for that. Otherwise, let me know. I'll check the comments, and we'll do this again next week. Thanks a lot, guys. Talk to you soon.